Contention raised by the counsel for the applicant is that PW1 was suffering with a serious ailment like and so he could not examine himself in the court on a few dates and adjournment was sought and also granted by the court, but later on at some stage that adjournment was refused and evidence of pw1 was closed in the midway. This closure of his evidence is likely to cause serious prejudice to the interests of the prosecution. Another submission is that the statement of PW2 also appears to have been misplaced and in place of it some carbon copy is said to have been kept on the record and that also speak about the high irregularities which has crept into the proceeding, and in that regard the statement of PW2 needs to be recorded again, but the presiding officer seized with the matter is not acting in accordance with law. Therefore, the proceeding should be transferred to any other count para. While rebutting the submission placed by applicant counsel, it was pointed out by Sri Rahul Chaturvedi, learned counsel for the opposite party number 2, that the matter has already reached at its terminating stage and the transfer application has been moved only with the object to scuttle and stall the proceeding. Moreover, if the applicant felt aggrieved by any of the order passed by the court below, they should have been challenged before the superior court, which has not been done so far, and instead of challenging the judicial orders passed by the court below in superior court, the applicant had jumped the gun and chose to move the transfer application, which does not appear to be a justifiable cause. It was also pointed out that he accused are in jail and any unnecessary unnecessary prolongation of proceeding will seriously prejudice the rights of the accused. Para. All the contention which have been placed by the applicant counsel appear to be in the nature of criticism of the orders passed in judicial capacity by the trial judge. If any order make the applicant aggrieved, he should have challenged the same in the superior court, adopting proper legal recourse, but the same does not appear to have been done. A judicial officer may pass a correct order and may also pass an incorrect order. That is how and that is why superior court come into play to look into the correctness of the subordinate court's order and then pass appropriate order with regard to the same. Difference court, like the courts of revision, the courts to entertain application US 482 CRPC, the courts to exercise power to issue writ, etc. With separate jurisdiction have been carved out to exercise such respective jurisdiction in the High Court, but passing of the incorrect order, even if it is presumed that the same has been done, does not constitute a legitimate ground to transfer the trial. Para. While exercising the jurisdiction of transferring a trial from one court to another, this court does not deem it fit or even proper to adjudicate upon the legality or otherwise of the order passed by the court below. There is hardly any material available on the record which may indicate that the presiding officer is for or was acting unfairly or dishonestly or was acting with prejudice or was influenced by some extraneous consideration, and therefore this court feels declined to interfere or to proceed to transfer the trial. The alleged incorrect or the legal approach of the trial court must reflect that the same owes its genius to some extraneous extra judicial factor which may be said to have tainted the judicious approach of the judge. Unless such a possibility appears plausible, this court ordinarily does not feel persuaded to exercise powers US 407 of CRPC only on the ground of the trial judge having passed some incorrect order.